Usually when we talk about a traffic ticket, even a really bad one, like say a reckless driving citation or blowing past a scale house, there's this expectation of a standard process.
Right, a transactional kind of thing.
Exactly. You get pulled over, you get the citation, maybe you hired a lawyer, pay a hefty fine, take a defensive driving class, and you move on. It's a bump in the road.
Yeah, it hurts the wallet, but your career keeps rolling.
But then you step into the world of a DOT drug or alcohol violation, and suddenly that transactional nature is just completely gone.
Oh, absolutely. It vanishes.
We are looking at a regulatory landscape that acts as an immediate, hard, unforgiving stop on a commercial driver's license career. If this happens to you, the phrase you're going to hear from your safety manager or, your HR department is, you have to complete the SAP program.
Yep, the dreaded SAP program.
And honestly, that phrase sounds deceptively simple.
It really is the absolute definition of diagnostic muddy waters for a lot of commercial drivers. I mean, when you hear the word program, it sounds like one specific thing.
Right, like a class.
Exactly. It sounds like signing up for a weekend seminar at a local community college, sitting in the back row with a cup of bad coffee, getting a certificate of completion, and just handing it to your dispatcher on Monday morning.
Like, here's my piece of paper, put me back in the truck.
Yeah, but the reality of the substance abuse professional process is entirely different. It is a highly complex, multi-tiered regulatory framework.
So for you listening right now, the commercial truck driver who might be facing this, or maybe you know a buddy in the industry who is currently sidelined by a violation. Our mission today is to tear down the massive misunderstandings surrounding this entire process.
It's so needed.
We're going to walk through the entire life cycle of a DOT violation, from the exact moment a driver becomes prohibited from driving to the very moment they are legally allowed to put the keys back in the ignition of a commercial motor vehicle. Okay, let's unpack this because today's deep dive is really about giving you the exact roadmap to save your CDL career from, frankly, completely unnecessary and agonizing delays.
That is the perfect way to frame our discussion today. Because the absolute worst thing a driver can do is view this process simply as a punitive measure.
Like it's just a punishment.
Right, a punishment handed down from the Federal Motor Carrier Safety Administration. But it's not. It is a meticulously designed safety protocol.
Okay, so it's more about safety than just penalizing the driver.
Absolutely. It's meant to protect the public on the highways, obviously, but it is also designed to provide a very structured, verifiable, and clinical path back to the wheel for the driver. Understanding the sheer mechanics of this system is, well, it's the only way you can successfully navigate it.
Because if you fight it,
If you fight the system or try to take shortcuts, I mean, you will lose months of income, plain and simple.
let's start with the immediate aftermath of the violation. The moment that drug test comes back positive or you refuse a test or, you blow over a .04 on a breathalyzer. From our source material, this isn't just a slap on the wrist or a temporary suspension by your specific company. It is a massive, system-wide shutdown.
It really is. Under the federal transportation regulations, the moment you have a verified DOT drug or alcohol violation, you cannot perform safety-sensitive duties for any employer, period.
Any employer. Wow.
It is an immediate and total prohibition. You cannot drive a commercial motor vehicle, you cannot dispatch, you cannot even load a truck if it falls under those safety guidelines.
I want to push back on that slightly because, in the old days of trucking, if a guy got caught by motor carrier A, he might just quietly clean out his truck, skip town, and go drive for motor carrier B a few states over. Does that loophole still exist at all?
No. It has been completely slammed shut.
Really? Completely?
You cannot switch employers to outrun this anymore, and the reason is the FMCSA clearinghouse.
The clearinghouse.
Yeah, this is a secure, central online database that gives employers, the Federal Motor Carrier Safety Administration, state driver licensing agencies, and law enforcement personnel real-time information about commercial drivers' drug and alcohol program violations.
So it's basically a permanent digital rap sheet for your CDL.
That's a good way to put it. It's a digital footprint that follows your commercial license everywhere. Every prospective employer is federally required to query this database before they put you in a truck.
So they have to check it.
They have to.
Yeah.
And if you have an unresolved violation, your status in the clearinghouse shines like a neon sign saying prohibited. And what's even more crucial now is that the clearinghouse actively communicates with state licensing agencies.
Which means what exactly for the physical piece of plastic in the driver's wallet? Because I think a lot of people assume their CDL is perfectly fine. They just, aren't allowed to use it for a while.
And that assumption will get a driver in massive trouble. A driver who remains in a prohibited status can actually lose their commercial driving privileges at the state level until the required return-to-duty steps are completed.
Wait, they actually lose the license?
Yeah.
Yeah.
The federal database talks to the state DMV, and the state proactively downgrades the CDL to a standard Class D operator's license. The state knows you are prohibited federally, and they pull the plug.
Wow. So ignoring this problem does not make it disappear. It literally makes your commercial license vanish. You
Yeah.
can't just sit on the couch for 6 weeks, get clean, feel great, and decide you're ready to hit the road again.
Exactly. The regulations establish a very specific return-to-duty process that must be meticulously completed. And the very first formal step to fix this prohibited status is obtaining a qualified substance abuse professional, or SAP.
Okay, this is where I found some of the most confusing stuff in our research. Because I think a normal person's reaction is like, hey, I have health insurance. I have a great therapist who helped me through a divorce a few years ago. Why can't I just go to my regular doctor or my therapist, have them write a note saying I'm fine, and give that to my employer?
It's a totally logical thought process for the driver, right? But the DOT is incredibly strict about rejecting that exact scenario.
Why is that?
Because not every counselor, therapist, rehab center, or physician is automatically qualified to serve as a DOT SAP. The federal rulebook establishes highly specific professional credentials, fundamental training, an intense examination, and ongoing continuing education requirements for these individuals.
So they are a highly specialized breed of evaluator.
Very specialized, and their operational mindset is fundamentally different from a standard therapist. When you go to your personal therapist, their duty is to you, the patient. They are your advocate.
Right, they're on your side.
Exactly. They want you to feel better. They want to support your life goals. A SAP is not your advocate. They are not your attorney. And this is important. They are not the employer's attorney either.
Then who are they advocating for?
Traveling public.
Oh, wow.
Yeah. Their fundamental regulatory responsibility is to protect the public interest in transportation safety. They do that through an objective clinical evaluation of the driver. They are looking at you and asking, is this individual safe to operate an 80,000-pound vehicle at 70 miles per hour on a highway with families in minivans?
They are the gatekeepers for public safety. It's almost like the difference between a defense attorney and a judge. Your personal therapist is your defense attorney, trying to get you the best outcome. The SAP is the judge, looking at the strict facts of safety and risk.
That is a brilliant analogy. The SAP has to remain completely objective. Now, finding one of these specialized judges, so to speak, is another area where drivers get completely lost.
Let's explore that because something blew my mind from the source text regarding the employer's obligation. Let's say I am a driver. I just failed a random drug test. My employer calls me into the office, fires me on the spot, tells me to clean out my cab and get off their property. Do they still have a legal obligation to help me find this specialized SAP,
They absolutely do.
even after firing me?
Yes. When an employee or even a job applicant who fails a pre-employment screening has a DOT drug or alcohol violation, the employer is federally required to provide that individual with a list of readily available qualified SAPs, and they cannot charge the driver for providing that list.
So even if the employment relationship is completely severed, the employer still holds a piece of the responsibility for the federal return-to-duty process.
Right. The employment relationship being terminated is a totally separate issue from the federal safety protocol. A driver should never sit at home thinking, well, they fired me, so they owe me nothing, and I'm totally on my own to figure this out. The DOT specifically advises employees to demand that list from the employer if it isn't volunteered.
Okay, but let's imagine a scenario where the employer is being difficult or maybe the driver just decides to take matters into their own hands and look for a SAP on their own. The source material has a pretty intense warning label about trying to research SAPs yourself on Google.
The danger there is very real. The Department of Transportation does not maintain a public, centralized government website listing every single qualified SAP in the country.
Which is wild to me, by the way.
It is. So naturally, drivers go to search engines. They type in SAP program near me or DOT SAP.
And I imagine they get flooded with ads.
Hundreds of them. But you have to be incredibly vigilant. An advertisement online that boldly claims SAP program or DOT classes does not guarantee that the individual on the other end of the phone actually meets the federal qualification requirements we just discussed.
Really? They can just advertise that.
Oh, yeah. There are a lot of generic addiction counselors or life coaches who use those keywords to drum up business, but they do not have the actual DOT credentials.
Which means a driver could end up paying hundreds or thousands of dollars out of pocket to someone, going through weeks of counseling, and then finding out none of it counts because the person wasn't a federally recognized gatekeeper.
And that happens far more often than you would think. You must independently confirm that you are dealing with a DOT-qualified substance abuse professional who can legally participate in the FMCSA clearinghouse process before you sign a contract or hand over a single dollar.
You got to be your own advocate there.
Exactly. You ask for their credentials, you ask for proof of their recent DOT continuing education, and you make sure they know exactly how the clearinghouse works.
That sets up our next major hurdle. Once you find this qualified SAP, you have to formally connect with them. Our notes refer to this as the designation process and the no shopping rule. Let's talk about the clearinghouse workflow here, because it's not just calling the SAP and saying, hey, I'd like to hire you. There's a very specific technical dance you have to do to make it official.
Yeah, for FMCSA regulated drivers, choosing SAP bridges the physical world of professional healthcare and the digital world of the federal database. The workflow requires the driver to contact the professional in the real world first.
Like a phone call.
Right, you have to call them, discuss their fees, their availability, and establish a relationship. You don't just log into your clearinghouse portal and blindly select a name from a drop-down menu without ever speaking to them.
Well, that makes sense because the SAP has to actually agree to take on your case. I mean, they might be fully booked or not accepting new clients.
Exactly. Once you both agree to work together, the driver logs into the clearinghouse and officially designates that specific professional as their SAP. The SAP, who is also logged into their own registered side of the system, receives that electronic request and accepts it.
So that digital handshake happens, and suddenly the clearinghouse dashboard becomes the driver's lifeline. It's basically like a FedEx tracking number for their entire career recovery.
That's a great way to put it. The SAP begins reporting all the required regulatory milestones into the clearinghouse, and the driver uses that dashboard to track their progress through the entire return-to-duty process. But here is the critical warning for drivers. Once you lock that SAP in and they conduct the evaluation, you are permanently locked in.
The source material calls this the no SAP shopping rule. And this is fascinating to me from a human behavior standpoint. Under the federal guidelines, once a driver has been evaluated, they cannot seek a second opinion just because they don't like the SAP's recommendation.
The absolute rigidity of this rule often catches drivers off guard. The DOT explicitly prohibits SAP shopping. You can't do it, and your employer can't do it either.
Wait, really? The employer can't either?
No. If an employer thinks the SAP was way too lenient and wants a harsher treatment plan, they are out of luck. The original SAP's recommendation controls the entire trajectory of the process.
Let's put a face to this to make it real. Let's follow a hypothetical driver. We'll call him Brian. So Brian gets a verified positive DOT drug test for marijuana. He gets pulled from his truck. He finds a qualified SAP, does the digital handshake in the clearinghouse, and goes to his initial evaluation. The SAP looks at his history, assesses his risk, and recommends a lengthy educational course combined with, say, 6 weeks of intense outpatient counseling.
And Brian is likely not going to be happy about that.
Not at all.
He might think it's too much work, it's going to take too much time, or it's too expensive. He might think his marijuana use was just a one-time mistake on a weekend and doesn't warrant intense counseling. So his natural instinct is to find a different answer.
Right. So he searches online, finds another SAP 2 towns over who advertises a cheaper, faster program, calls them up and says, hey, this first guy wants me to do 6 weeks of counseling. Can I just pay you to give me an 8-hour class instead?
Yeah, that happens a lot.
It's like going to an orthopedic surgeon with a shattered leg, and when they tell you that you need surgery, pins, and 6 months of physical therapy, you just keep driving to different urgent care clinics until one doctor finally says, nah, just put a Band-Aid and some ice on it, you're fine to run a marathon. The DOT does not let you play that game with public safety.
They absolutely close that loophole. The regulations explicitly state that the original SAP's recommendation is binding. You cannot go out and buy a more favorable, cheaper, or faster answer.
Wow.
The only way a treatment plan changes is if that original designated SAP modifies the recommendation themselves because new or additional clinical information comes to light during your treatment.
So the overarching lesson here is to do your homework before you designate them in the clearinghouse. Because once you sit down in that chair for the evaluation, you are married to whatever treatment plan they construct for you.
Exactly. Which brings us to the actual clinical work, the initial evaluation itself.
I really want to dig into this because what does this room actually look like? What is the SAP doing? Is it just a quick conversation, a multiple choice quiz about drinking and driving?
No, it is a comprehensive, deep dive clinical assessment. The SAP's sole purpose during this initial evaluation is to determine exactly what level of assistance this specific driver needs to resolve issues related to alcohol or drug use.
Is it always in person?
It is typically conducted face-to-face in person, though under certain specific DOT-permitted circumstances, it can be done remotely using real-time, two-way audio and video. But the operative word is comprehensive.
What are they actually looking for, though? If Brian sits down, how does the SAP know if he has a severe addiction problem or if he just made a really dumb choice at a barbecue?
Well, the SAP uses a variety of clinical screening instruments, structured interview techniques, and psychological profiling tools. They are going to take a deep personal history, medical history, a history of substance use, family dynamics, and professional background.
They really dig in.
They have to. They are looking for patterns of behavior, coping mechanisms, and markers of dependency. They are also assessing the driver's attitude toward the violation itself. Is the driver taking accountability, or are they blaming the testing clinic, their dispatcher, and everyone else?
They are gauging the risk of a relapse while behind the wheel. And the driver needs to approach this with absolute seriousness. You can't just walk in, cross your arms, and give one-word answers hoping to get out of there in 20 minutes.
No, because if you stonewall the SAP, you are only hurting yourself. They are making a profound professional determination about public safety and your livelihood. If they sense deception or an unwillingness to engage in the clinical process, their risk assessment of you goes up, which means your required treatment plan will likely be more intense.
And this leads to another huge misconception we need to clear up. Let's look at a different guy. We'll call him Marcus. Marcus finishes this intense initial evaluation. It took a few hours. He feels like he really poured his heart out. He leaves the office, calls his buddy, and says, "Great news. I finished the SAP program. I met with the counselor. We talked it all out. I should be back to work next week."
Yeah, and Marcus is fundamentally confused about the architecture of this system. He has completed step one of a multi-step checklist. The first appointment merely starts the process. It absolutely does not finish it.
He basically showed up to the starting line of a marathon, tied his shoelaces, took one step, and called his friends to brag about finishing the race.
Exactly, because what comes next is the prescription of education and treatment. And this goes back to what we were saying about there being no universal program. The SAP must prescribe a course of action that the driver has to successfully comply with.
Let's explore the individualization of this, because I imagine it causes a lot of friction in the trucking community. Say our guy Marcus goes to his SAP and gets prescribed this massive, extensive outpatient counseling program. But his buddy John, who drives for the same company and failed a drug test for the exact same substance on the exact same day, goes to a different SAP and only gets prescribed a short, one-day drug and alcohol education course.
Oh, this happens all the time.
And Marcus finds out about John's plan, and he is absolutely furious. He's yelling, "That's not fair. We committed the exact same violation. Why do I have to do all this extra work?"
This raises a fascinating point about how drivers perceive fairness and justice within the regulatory system. Marcus is viewing the SAP process as a standardized penal system, a punishment for a crime.
Right, like a mandatory minimum sentence.
Exactly. In the criminal justice system, if the crime is identical, you generally expect the sentence to be roughly identical. But the DOT process is not a penal system. It is a clinical, safety-oriented evaluation of underlying human issues.
So the SAP isn't punishing the drug test failure. They're treating the human being attached to it.
Exactly. The SAP evaluated John and determined, based on his clinical history and psychological profile, that his risk level was low and his underlying issues could be resolved with basic education. They evaluated Marcus and determined his underlying issues, coping mechanisms, or history required a much more robust clinical intervention to ensure he wouldn't relapse behind the wheel.
It's about resolving the specific problem so they're safe to drive, not handing out standard mandatory minimum sentences. Now, here is a crucial mechanical detail I want to clarify. The SAP evaluates you. They prescribe this customized treatment. But do they actually provide the treatment themselves? Like, if Marcus needs 6 weeks of counseling, is he going back to that same SAP every Tuesday?
Typically, no. And this is a very important distinction. The SAP acts as the professional evaluator and the referral source. They evaluate you, build the treatment plan, and then refer you to an outside education provider or a specialized treatment facility to actually do the work.
So if we use an analogy, the SAP is basically the architect who draws the complex blueprints for your recovery,
Hmm.
but they send you to a separate general contractor out in the community to actually build the house.
That is a perfect way to visualize it. The architect doesn't swing the hammer, and by the way, there are strict federal conflict of interest regulations built into this.
Really? Like what?
Well, the DOT wants to prevent SAPs from just referring drivers to their own side businesses or private clinics simply to make a profit off the treatment phase.
Ah, that makes total sense. You don't want the judge getting a kickback from the prison. So your SAP and your treatment provider are likely going to be two completely different people or organizations.
Yeah, and the driver's responsibility during this phase is incredibly simple, yet so many mess it up you must complete everything the SAP requires. If the architect drew the blueprints for a 3-story house, you can't just build 2 stories, tell the contractor you feel cured, and call it a day.
Right. If they prescribed 6 counseling sessions and weekly self-help meetings, you can't decide after 4 sessions that you've got the gist of it and stop showing up. You have to obtain the documentation, keep every certificate, keep every receipt, and ensure the treatment provider communicates with the SAP. Because mere participation is not the goal here. Successful compliance is the goal.
Which perfectly sets up the next critical phase, the follow-up evaluation. We call this the second bookend.
Let's dive into this second bookend, because according to the research, this follow-up evaluation is a massive sinkhole where a shocking number of drivers just fall off the map and ruin their careers. Why does this happen?
It happens because drivers logically, but incorrectly, assume that finishing the treatment is the final step. The federal rulebook dictates that the SAP must conduct a formal follow-up evaluation.
So they have to go back to the architect.
Exactly. They have to review the discharge documentation from the treatment provider, conduct another face-to-face clinical interview with the driver, and formally determine if the driver successfully carried out the prescribed recommendations.
The two bookends of the process. The first evaluation determines what must you do to become safe. The second evaluation determines, did you actually do it, and are you safe now?
That is the exact mechanism. Let's look at a scenario. Let's say we have a driver, Anthony. Anthony actually finishes his treatment. He goes to his education class, sits there for 8 hours, and the instructor hands him a nice printed certificate of completion. Anthony goes home, puts that certificate in his drawer, and assumes he is done.
He thinks the class instructor is going to notify the DOT.
Right. 6 months later, he applies for a great driving job, and the recruiter runs his clearinghouse record and says, "Sorry, Anthony, you are still in a completely prohibited status."
Because he never went back for the second bookend to have the house inspected.
He missed the most critical administrative step. The education provider or the counselor cannot log into the FMCSA clearinghouse and declare Anthony eligible. They don't have the authority. Only the designated SAP can do that. And drivers need to understand a sobering reality: showing up for this follow-up evaluation does not guarantee automatic approval.
Wait, what do you mean? If he did the classes, shouldn't he be cleared?
Not necessarily. The SAP can look at your progress, read the counselor's notes, interview you, and determine you have not successfully complied.
Oh, wow.
They can say, yes, you physically sat in the chairs for 6 weeks, but you didn't actually engage with the material, you were combative with the counselor, and clinically, you still present a significant risk. You are still prohibited, and I am prescribing more treatment.
That is heavy. So the SAP really does retain total control over the safety determination. But let's be optimistic. Let's assume our guy Anthony went to treatment, did the hard work, engaged with the counselor, and the SAP conducts the follow-up and determines he successfully complied. The SAP then logs into the clearinghouse and reports that Anthony is eligible for return-to-duty testing.
And here is where we hit the biggest illusion in the entire regulatory process. The SAP updates his status in the digital portal to eligible for return-to-duty testing. What does the driver think when they see that status?
I can tell you exactly what they think, because here's where it gets really interesting. They think, I am cured. I am not prohibited anymore. I can drive a truck today. Let's talk about Rebecca. Rebecca sees that status. She is going to call her dispatcher and say, my SAP cleared me. Put me on a load for tomorrow morning.
And the regulatory expert in me has to strictly correct Rebecca here, because that assumption can lead to catastrophic fines for both her and the carrier. The SAP did not clear her to drive.
But the status says eligible.
SAP eligibility is merely federal permission to take the return-to-duty test. It is not permission to operate a commercial motor vehicle. She is still 100% prohibited from performing any safety-sensitive duties.
So she basically fought her way through the entire clinical process just to earn the ticket to enter the arena, but she hasn't actually fought the final battle yet.
Yes. The correct phrasing she should have used with her dispatcher is, "My SAP has determined that I am now legally eligible to take my return to duty test." It is a massive distinction. And that final battle, as you call it, is a very specific type of test.
Let's break down this test, because this is where things get intensely physical and, frankly, very invasive. We're talking about the actual return to duty or RTD test requirements. What are the baseline rules here?
Well, first, you cannot take this test until the SAP gives that official green light in the clearinghouse. If your original violation was for drugs, you need a verified negative DOT RTD drug test result. If your violation was for alcohol, you need an alcohol breathalyzer result below a .02. And depending on the SAP's clinical evaluation, they have the authority to order you to take both a drug and an alcohol test, regardless of what your original violation was for.
Okay, but here is the absolute grenade sitting in the middle of this step. The phrase mandatory direct observation.
This cannot be overstated to any driver listening. The Federal Transportation Guidelines dictate that DOT return-to-duty drug tests must be conducted under direct observation.
Let's be blunt about what that means. That means another human being is standing in the bathroom with you, directly watching the urine specimen leave your body and go into the cup.
Yes, it is substantially different and far more invasive than an ordinary, unobserved, random, or pre-employment urine collection where you go into a stall alone.
Why does the DOT mandate something so extreme? It feels like a massive violation of privacy.
I know, but the DOT implements this specifically for return to duty and follow-up testing because a driver in this phase has already proven they have a substance issue by violating the regulations once. The statistical motivation for that driver to try and cheat the test using synthetic urine, substituting someone else's clean urine, or using an adulterant to mask drugs is incredibly high because their entire career is on the line. Direct observation is the DOT's ultimate safeguard against test cheating.
I understand the safety logic, but drivers absolutely need to know this before they walk through the door of the clinic, because if they are caught off guard, their reaction can ruin their life. Let's introduce another driver here. Let's call him Terry. Terry completes all his SAP work. Months of counseling, lots of money spent. He shows up to the clinic for his RTD drug test. The collector hands him a cup and says, "Okay, Terry, this is an RTD test, so I have to come in the bathroom and directly observe you."
And Terry is not prepared for that.
Exactly. Terry feels completely humiliated. He gets angry. He yells at the collector, "I just spent 3 months in counseling. I'm clean. I paid my dues, and nobody's watching me go to the bathroom like I'm some kind of criminal." He throws the cup on the counter and storms out of the clinic in a rage.
And in doing so, Terry just nuked his career all over again.
Because storming out is considered a refusal.
Absolutely. Refusing a directly observed collection when it is federally required constitutes a brand new refusal to test violation. Terry spent months working through his first violation, and in 5 minutes of understandable but misguided anger, he triggered a second, completely separate violation.
Oh, man.
Now he is back to square one. He has to start a brand new SAP process with a new evaluation and new treatment for the new refusal.
All because he didn't know the mechanical regulations of the test. That is heartbreaking. Okay, so you know you have to take the test. You know it's going to be directly observed, so you mentally prepare for that. But who actually schedules this test? Because the research material highlights this as one of the most frustrating areas of confusion.
It is a huge trap. The SAP does not schedule the return to duty test. The SAP cannot send you to a clinic on their own authority.
Wait, really? The architect doesn't order the final inspection?
No. The federal rules require that the employer directs the return to duty test. The employer controls the testing process. They order the specific DOT test. They direct you to a specific clinic, and they, or their authorized third-party management company, are responsible for reporting the negative result back to the clearinghouse.
This perfectly explains a nightmare scenario I read about. Let's talk about Carlos. Carlos finishes everything. The SAP updates the status to eligible. Carlos goes home, sits on his couch, and waits. A week goes by. 2 weeks. A month. He finally calls the SAP, furious, and says, "I've been sitting for a month, losing money. When are you going to schedule my test?"
And Carlos lost a month of income simply because he didn't understand the distinct roles. The SAP determines eligibility. They are the clinical gatekeeper. The employer directs the test. They are the operational gatekeeper. If Carlos had a company waiting to hire him, he should have called their safety department a month ago to initiate the test.
And then there's the driver who tries to be overly proactive and take matters into his own hands. Let's call him Steven. Steven sees he is eligible.
Yay.
He drives down to a local generic urgent care or occupational health clinic, walks up to the receptionist and says, "I need a drug test for work." He pays $60 out of pocket for a standard 5-panel urine test. It's not observed. It's just a regular test. It comes back negative. He emails a PDF of the result to his SAP and his employer and says, "Boom, passed it. Put me in a truck."
And he just threw $60 out the window.
It doesn't count.
Not at all. A generic workplace drug test or a non-DOT test is completely worthless for this process. An RTD test must be properly ordered by a motor carrier under strict DOT chain of custody procedures. It must use a specific DOT testing panel, and as we hammer it home, it must be directly observed. A driver can never self-design or self-order their RTD test.
So the SAP can't order it, the driver can't order it, only the employer can order it. This brings up a massive glaring problem. What if you don't have an employer? What if you were fired on the spot for the original violation 6 months ago? You went through the whole SAP process on your own dime, and now you were sitting there eligible to test, but totally unemployed.
This is the ultimate regulatory catch-22 of the DOT system. It is incredibly frustrating for drivers.
Let's map out this trap. We'll use David as an example. David is unemployed. He finishes his SAP work. His status is eligible for RTD testing. He applies to 5 different trucking companies. He's a great driver otherwise, so they all want him. But every single recruiter pulls his clearinghouse record, sees his status, and says, "Sorry, David, our insurance won't let us hire you while you are still in a prohibited status. Go get your negative RTD test, get your status changed to not prohibited, and then we will gladly hire you."
But David can't get the negative RPD test until an employer officially sends him to take it.
Exactly. The employer says, "Get the test, then we'll hire you."
Yeah.
The DOT says, "You must be hired for an employer to order the test." David is completely boxed in. He can't get a job without the test, and he can't get the test without a job. He is permanently prohibited.
Historically, this was a massive flaw in the regulatory architecture that left drivers entirely stranded, sometimes for years. But the FMCSA recognized this gridlock and created a very specific loophole, a regulatory workaround, for exactly this situation.
Walk me through this workaround in detail, because for an unemployed driver listening to this is an absolute lifeline.
If a driver does not have a current or prospective employer willing to sponsor and direct the RTD test, the FMCSA allows the driver to log into the clearinghouse portal and register themselves as an owner-operator.
Let me stop you right there and clarify this, because that sounds insane. Do they have to go down to the bank, take out a massive loan, buy a $150,000 semi-truck, set up an LLC, and apply for a federal U.S. DOT number just to take a drug test?
No, absolutely not. And that is a critical point that creates a lot of anxiety. The FMCSA explicitly advises that drivers should not apply for a U.S. DOT number or start a real trucking company merely to use this option. You are simply utilizing a specific registration classification within the digital framework of the clearinghouse system itself. You check a box that says owner-operator.
Okay, so you legally classify yourself as an owner-operator in the portal. Then what? You still can't print out an order form for your own test, right?
Correct. You cannot act as your own employer for the purposes of drug testing. Once registered as an owner-operator in the system, the driver must then designate a consortium third-party administrator, which the industry refers to as a CTPA.
Right. These are the private drug testing management companies that help trucking companies run their random testing programs.
Exactly. You hire one of these companies and designate them in the clearinghouse for the limited purpose of managing your return-to-duty process. That designated CTPA essentially steps into the legal shoes of the employer. They have the federal authority to legally direct you to take the DOT RTD test. They ensure the clinic conducts it under direct observation. They receive the result from the medical review officer. And most importantly, they have the systemic authority to report that negative result back into the clearinghouse on your behalf.
That is brilliant. It breaks the gridlock completely. David pays a small fee to hire a CTPA. They order the test. He passes it under direct observation. The CTPA uploads the negative result, and boom, his status changes to not prohibited. Now he can go back to those 5 recruiters. They pull his file, see he is cleared, and he gets the job.
It is a vital career-saving lifeline. But the driver has to know it exists, they have to know how to navigate the portal, and they have to execute it properly within the clearinghouse rules. It requires the driver to be highly proactive.
Which perfectly transitions us into the final stretch of this journey, crossing the finish line and the aftermath. Because even when the test is done and you pass, the driver still has to take ownership of the digital paperwork.
The next crucial step is verification. You must verify that the negative RTD result is actually reported into the clearinghouse. The FMCSA requires the employer, or the CTPA we just talked about, to officially report that result. The magical moment your status legally changes from prohibited to not prohibited is the exact second that data is entered into the system. It is not when you pee in the cup.
The research gave us a tragic story about a driver who failed to verify. Let's call her Lisa. Lisa takes her directly observed test. She passes. The clinic nurse tells her, "Looks good, you passed." Lisa goes out to a steakhouse, celebrates with her family, assumes she is golden, and waits for a call from dispatch. 2 weeks later, she hasn't heard anything, so she applies for a different job. The new recruiter runs her file and says, "Lisa, what are you doing? You're still prohibited."
Because someone in the administrative chain dropped the ball. Maybe the clinic didn't send the paperwork to the medical review officer fast enough. Maybe the MRO had a backlog. Maybe the employer's HR person went on vacation and forgot to log into the clearinghouse to upload the final result. Lisa relied on verbal confirmation from a clinic worker. But a professional commercial driver must verify the system of record.
Trust but verify.
Always log into your own dashboard. Look at your actual status. If it doesn't say not prohibited in green letters, you need to start making phone calls to your employer or CTPA immediately to find out where the data bottleneck is.
Okay, let's assume the system works. The driver logs in and they see those beautiful words, "not prohibited." The nightmare is over. The anxiety is gone. The SAP obligation is completely finished, and they can just go back to being a normal truck driver.
Not even close.
Oh boy, I knew there was a catch. What is hanging over their head now?
This is one of the most dangerous misconceptions for a driver's long-term career. Not prohibited simply means the unresolved violation is no longer acting as a hard stop preventing you from performing safety-sensitive functions. You are legally allowed to drive a truck again. However, your relationship with the SAP process is absolutely not over. The federal rulebook mandates that the driver will be subject to a mandatory SAP-prescribed follow-up testing plan.
We're talking about unannounced testing on top of the normal random testing pool.
Yes. When the SAP determined you were successfully compliant back at the follow-up evaluation, they didn't just write "cleared" on a piece of paper. They also created a highly specific, written follow-up testing plan. They decided the exact number of tests you must take, the frequency of those tests, and whether they are for drugs, alcohol, or both.
And what's the typical time frame for that?
The federal minimum is at least 6 unannounced tests in the first 12 months of returning to duty. But SAP can mandate testing for up to 60 months. That's 5 years.
5 years of extra testing? But the driver doesn't get to see this schedule, right? It's not like they get a calendar with red circles on the days they have to test.
Correct. That would defeat the entire purpose. The clinical plan goes directly from the SAP to the employer's designated employer representative, or DER. The tests must be truly unannounced. If you knew the schedule, it wouldn't be a valid monitoring tool to prevent relapse.
This brings us to a huge mistake drivers make regarding paperwork. Let's look at a driver named James. James sees his status change to not prohibited. He is so relieved that the ordeal is over. He goes into his home office, grabs his entire folder, the initial SAP evaluation, the education certificate, the clinical follow-up notes, the clinic receipts, and throws the entire thing in the shredder. He tells his wife, "It's over. I'm done with all that junk."
And James has just made a massive strategic error for his career, because that follow-up testing requirement is attached to the driver, not the employer. If James works for motor carrier A for 6 months, takes 3 of his follow-up tests, and then quits to go drive for motor carrier B, that testing plan follows him.
Oh, I see.
Motor Carrier B is federally required to obtain the SAP plan from James, or the previous employer, and continue administering those unannounced tests until the entire plan is complete.
So if James shredded all his paperwork and motor carrier A goes out of business or refuses to send the files, James is stuck. He can't prove to motor carrier B what his testing plan is, which means motor carrier B can't legally dispatch him.
Precisely. You have to maintain a personal career file. You need to keep every single piece of paper generated during this process. And the smartest thing a driver can do is track their follow-up tests after they happen. Keep a log.
Like a personal record.
Yeah.
Right.
So if the SAP ordered 12 tests and you know you've taken 8, you have a record of exactly where you stand if you change jobs. Not prohibited is a huge milestone, but it is not the end of your regulatory responsibilities.
Speaking of changing jobs and employment, we really need to talk about the harsh employment realities of this entire process. Because completing the federal checklist does not guarantee you a paycheck. Let's look at Michael. Michael gets a violation and gets fired by his mega carrier. He grinds through the entire SAP checklist, the initial evaluation, the weeks of treatment, the follow-up. He pays for the CTPA workaround for the test, and he finally gets his status to not prohibited.
Good for Michael.
Right. But then he calls up the safety director at the mega carrier that fired him and says, okay, I did everything the DOT asked. Federal law says I am safe to drive now, so you have to give me my job back.
And Michael's fundamentally confusing federal regulatory clearance with private employment law. The federal regulations are explicitly clear on this. Successfully completing the return to duty process does not create an automatic right to employment. The DOT process simply determines whether the federal government prohibits you from working. It does not dictate that any specific private motor carrier must hire you or rehire you.
So the safety director can just say, congratulations on getting your life together and getting cleared by the DOT, Michael. But our corporate policy is that we do not hire anyone with a past violation on their record for at least 3 years. Goodbye.
Exactly. It remains an employment and insurance decision for the carrier. The DOT says you can drive, but the employer decides if they want you to drive for them. And this harsh reality extends deeply into the financial side of the process as well. The regulations specifically state that an employer is not federally required to pay for your SAP evaluation, your subsequent education, or your clinical treatment.
Wait, really? Even if they don't fire you? Even if they keep you employed and just put you on leave, they don't have to pay for the rehab?
Correct. The DOT does not mandate who pays the bills. Payment arrangements are entirely up to the employer, your specific health insurance benefits, union contracts if you have one, or company policy. Drivers absolutely cannot assume the company is footing the bill and just wait around for HR to schedule and pay for the SAP. You have to ask direct questions, understand your financial exposure, and take control of the logistics yourself.
So what does this all mean? We've taken the listener through the entire labyrinth. The initial violation, the immediate prohibited status, navigating the clearinghouse designation, the complex initial clinical evaluation, the individualized treatment phase, the second bookend of the follow-up evaluation, the dangerous illusion of the eligible status, the invasiveness of the directly observed RTD test, the CTPA workaround for unemployed drivers, the final status verification, and the years of unannounced follow-up testing. When you look at this massive, complicated architecture, what is the grand takeaway for the truck driver listening right now?
The grand takeaway has to be a fundamental shift in a driver's mindset. A driver going through this process cannot be a passive participant. You cannot sit in the passenger seat and hope the SAP, the testing clinic, and your employer will seamlessly communicate and successfully drive you back to your career.
The driver has to act as the CEO of their own CDL career.
Exactly that.
Yeah.
The SAP process is a multi-tiered, multi-agency project, and you, the driver, are the ultimate project manager. You need to keep a written checklist. You need to document every single interaction. You must verify your status in the clearinghouse at every single stage. Because if a clinic nurse forgets to fax a form or an HR rep forgets to click a button, they aren't the ones who lose their livelihood and their house. You are.
It is entirely on your shoulders to make sure the boxes are checked. It's an incredibly complex machine, but it is a navigable one if you truly understand the mechanical rules we just discussed.
It is navigable. And, if we pull back and look at the bigger picture here, examining how this system operates really raises a profound question about the future of how our society handles safety and human fallibility.
How so? What do you mean?
Well, think about how rigid, data-driven, and highly tracked this FMCSA clearinghouse and SAP process actually is. It is an unblinking digital eye that monitors a professional from the exact moment they fail a safety standard through their highly specific, individualized clinical rehabilitation right back to their active duties, and then it continues to monitor them with unannounced testing for years afterward, following them from job to job.
It's incredibly intense. It leaves no room for shadows or secrets.
It doesn't. But as our society grapples more and more with complex issues of addiction, substance abuse, and mental health in the workplace, have to wonder if this strict, verifiable life cycle of recovery and monitoring is going to become the standard model everywhere. Not just for commercial truck drivers, but for airline pilots, trauma surgeons, train engineers, heavy machinery operators, maybe even public transit drivers. Is this highly regimented, inescapable federal architecture the inevitable future of all workplace safety where human error can cost lives?
That is a staggering thought. The idea that this trucking framework might be the blueprint for how we handle all high-stakes professions in the future. And it brings us right back to where we started this conversation. A DOT violation isn't just a bump in the road. It isn't a simple traffic ticket you pay off. It is a complete rewiring of your professional existence under the absolute strictest safety microscope we have in the modern workforce.
And understanding exactly how that microscope focuses and operates is the only way a driver can survive it and reclaim their career.
Well said. You have to know the rules of the game if you want to keep playing. To everyone listening out there on the road, navigating the scales on the traffic, thank you for joining us on this deep dive. Stay safe, stay informed, and we'll catch you on the next one.